Hi everyone, and welcome to this webinar on using and understanding contracts as tools for ensuring deliverables. We're delighted to have you all on the line with us. We'll get going with the webinar in a few moments. We'll give people a chance to kind of join and make sure that we kick off with as many people as possible in the webinar. It'd be great actually while we're waiting for people to join, there's a poll on, there's a tab on the side where it says questions that everyone should have. If you could click on the questions tab and let us know where you're dialing in from, it'd be great to understand whereabouts in Australia or even internationally where we have people dialing in from. Yep, so we've got a few coming through from Sydney, Perth, Canberra, Adelaide, all the kind of usual suspects here, Sean.
Yeah, and probably all got better weather than I've got in Melbourne, I would imagine. Well, except maybe for Canberra.
Yeah, maybe. We've got Toowoomba, we've got a few people dialing in rurally as well, which is great. Welcome to a few people from Adelaide. Where else have we got? Darwin, Cairns. Awesome. Well, yeah, it's great. We've definitely got a very widely diversified audience here today, Sean, which is great.
Fantastic. I wonder if we can get a political update from the person that's attending in Canberra. That would be good.
Definitely. It'd be good to see what their thoughts are down there.
See if they can see any leadership spills happening as we talk.
Yeah. Well, the news is on a lot in our office. There's definitely a lot going on down there.
There is.
Someone's just said still in the job.
What was that? Someone's
just written saying he's still in the job.
He is, that's right. We should put a question mark for how long.
Yeah, definitely. Well, we'll get going now with this webinar, and hopefully some more people will join us as well. So as I said, welcome to the webinar. We're going to be looking at the topic using and understanding contracts as tools for ensuring deliverables. I'm delighted to be joined here today by Sean McCarthy, who's going to be talking us through this subject. We're extremely lucky to have Sean here and be working with him. He's got a unique blend of industry and contract knowledge. Just to give you a bit of background about Sean before we get going, he previously was in the construction and building industry as a builder, a project manager and a contracts manager, before moving on to practice law and setting up his own private firm, where he's passionate about teaching and passing on a lot of the tricks of the trade that he's learned along the way. So welcome, Sean.
Yeah, thanks, Holly. I'm really pleased to be here because you know that I'm pretty passionate about this topic and have spent a lot of time with Informa and others and people that I advise through the practice as well, and talking to them and teaching them about contracts and how they're very effective tools. And as you said, my background was really in industry for many years, mostly in construction, but really I sort of migrated towards a lot of contract administration, a lot of roles where I would see the benefit of having a well drafted contract and even a good contract that could be administered to effectively deliver the project outcomes and try and ensure that you hopefully meet time and meet budget and achieve all of those other things. So yeah, I'm pretty passionate about it, and yeah, pleased to be here today.
Wonderful. Well, yeah, those meeting time and budget is always a big thing when looking at contracts, so it's an important point to mention. Just a bit of housekeeping actually before we get going to the main content of the webinar. It'll probably run for about 20 to 30 minutes in terms of the content, and then Sean and I will be delighted to stay on the line and answer as many questions as possible. So please do use that questions tab to communicate questions with us, and at the end we'll get to as many as we possibly can. So Sean, maybe we can actually start off with a little bit more about yourself. So you mentioned obviously the passion you have, which is great, and thinking about the work we've done together and the feedback we regularly get from your courses, you are so passionate about this topic. Why is that?
Yeah, look, that's a really good question, Holly, and thanks for the question. Look, it's I came from the background of really project management and contract administration, and I guess I always saw that projects were often competing with a number of different priorities, so that you were competing with time, sometimes competing with budget, but also, you're often, particularly in construction or particularly in infrastructure projects, competing with so many different variables. So, you might have, for example, very high dollar value projects. You might have lots of tiered layers of different subcontractors. You have changing conditions, stuff that happens that may not necessarily be predictable. And really, it's all about a long-term, I won't quite say a marriage, but it's almost like a bit of a marriage in the sense that you're often working with partners through some sort of formal contractual arrangement, hopefully. And what you need to be able to do is you need to be able to actually discover and learn and actually apply the terms of the contract. And the terms of the contract are, some people will say to me occasionally, look, you don't want to pull the contract out because it's a sign that things are going wrong, and I don't necessarily agree with that particular approach. What we have is we have a template and we have a guideline. We basically have parameters for how the relationship really is going to pan out and how we're going to deal with some of those things like variables. And so, if a contract has to be varied, or if things happen on a site, or, and I shouldn't narrow my discussion just to construction projects, you have so many different things that need to come up, and it might even be that you just need to document and articulate some sort of arrangement between the parties that's quite simple to say, okay, if Holly and I go into an agreement for a particular deliverable that, we will meet once a month to determine how the project is actually unfolding. But unless we articulate that, Holly, and write it down and have clarity between the parties, we're sort of really struggling. And look, I work with a lot of clients where projects are implemented sometimes late, or the contract might be late, or the contract may not have, heaven forbid, may not be actually, executed by the time we get into a contract, by the time we get into the project. And what we really need to do is to say, how can people learn to, not let those things happen? And look, I'm really passionate about it because I'm lucky enough to work as a lawyer with a lot of different businesses, but also, be regularly involved with you guys in teaching people. And I think the reason I feel so passionate about it is that, it's a fairly difficult skill, but it's a skill that can be learned, and it's a skill that can be acquired over time. And it's just basically a matter of learning how to apply it and how to use the contract to guide the relationship, guide the deliverables, and potentially deal with any remedies if things do go wrong. And look, it's proven over and over again that good contract management saves a lot of pain, I would have to say, and saves the potential of being litigated in disputes. It usually saves time, it usually saves money. And I often think of the example of, many students we've had go through the Informa courses, and, if we could teach them to simply manage a simple dispute or a variation claim of some sort by feeling comfortable with the contract, having looked at it, having practiced some of those skills, I can tell you those people are worth a lot of money to their particular organisation. So, look, I feel really passionate about it. I guess the other thing is that I came from a builder and project manager role. I've been lucky enough to discover that I can be a lot more academically inclined than what I originally thought. And so I've got the benefit of having done the law degree. But I think a lot of the principles we learn as lawyers and apply as lawyers are unnecessarily complex and can be conveyed to people in fairly simple terms. And look, I feel very strongly that if I've had the benefit of that education, then that other people should also be able to enjoy that benefit. And it's just a simple skill that you can learn and practice and develop over time. Sorry, that's a long answer to your question.
No, it's a good one. I particularly like the analogy of marriage with contracts. I think that's a nice description there. If you're looking at contracts per se, what do you think it is that deters people from effectively administering or managing contracts? I mean, are they really kind of that scary?
Yeah, look, I guess that's also a good question, because I guess, look, for any of us that have looked at a contract, and, even for those that have driven their car into a car park in recent times, or people that have renewed their insurance, it's usually not the most exciting read to do at any one particular time, to pull out the terms and conditions and have a look at them. So, look, I think just the contracts can be, look, they can be, I guess a couple of things put people off. One, they can be very large documents. So for example, if you're dealing with a tier 1 contractor in construction or a major supplier that contracts all the time, they might supply you with a very large and very unwieldy document for even for small arrangements. 2, they can be, they can be difficult, they can be convoluted. We often see sentences or clauses or referencing in contracts that, might be, 2 or 3 referencing points. So you might have a term that then references a clause that then references something in the schedule, and it might have exceptions. They can be difficult, but, probably one of the main things I think is that whenever we go into contract, what we choose to do is we choose to articulate both the obligations between the parties and potential remedies. And whenever we go to articulate something, Holly, we put it in Word. And whenever we put something in Word, there's always, there's always ambiguity. So if I say, I'm just trying to think of an example, I could say to you, yes, that's exactly what we want, or I could say, yes, that's exactly what we want, with a different intonation and sarcasm. And a contract never gets the subtleties of the tone or the intent. It's really a black and white document, and sometimes they're hard to interpret. So, I think of many examples in contracts where I might say to you, please use your best endeavours to make this a good seminar today, or please provide me with some feedback as soon as practicably possible. And they're all good, fun terms, and the ambiguity sometimes can be actually very good for a party as well. But look, they can be a little bit frightening and they can be a little bit scary. And I think the other thing is that, organisations often will have people that thrown into contract management. They may never have done a contract before, and they can be told, well, here you go, here it is, good luck, and see how you go. And I remember when I first went into project management, my first project that I ever managed was really, I asked my supervisor at the time whether there were any particular tips and traps for delivering a project of that particular nature. And he said, well, I could give you the tips and traps, but why don't you just see how you go? And sink or swim will be a good thing. So, I've been there, done that. But yeah, they can be just difficult documents. I think the other thing is that people think they're full of legalese, and they often are. So we might have words like aforementioned or hereinafter or promissory estoppel and lots of legal terms. And if you're not amongst it, or you're not sort of doing it all the time, then they can be a bit of a kick to it might potentially kick your confidence, really. So.
Yeah, definitely, Sean. I think it's a really good point there about, making sure that people know on the line that they are scary and that you're not alone. It's good that people with a bit more knowledge and confidence, they can obviously make sure they are administering contracts better. There was actually, you obviously hit a nerve there. There was a few people coming in with questions there, which we'll get to at the end. So please do keep them coming. It's obviously a topic that people are.
That's right. I think, sorry to interrupt, but often, people say, well, I don't feel very comfortable, or I'm not very good, or how do I hone my skills as a contract manager? And really what we've got to do is we've got to realise that, it's like going off and doing a qualification, or it's like going off and learning interpretive dance or something like that, that really what you need to do is it's just practice. And if we haven't got the miles in our legs in doing it on a regular basis, then of course, it's a little bit difficult. And that's where, it's often being able to convey ideas from experience to people is also very good, because just like if you were learning interpretive dance, I guess is my example. I guess you need a coach, or you need someone that will give you the methods and the tools and tips on how to get better at it.
Yeah, definitely. People aren't alone, and confidence and knowledge is key with that one, I think.
Correct. Yeah.
If you're looking at you personally, Sean, how do you personally view a contract? I mean, aren't they just there to be used when things normally go wrong?
Yeah, that's right. Some people say, I was at a course not so long ago actually, and some people said to me, well, I think the contract is in its best place if it's in the bottom left-hand drawer of the filing cabinet, because they really had the view that the contract is the baseline, and the contract really is an indication that things are going wrong, and so we take it out when things are going wrong. But really, nothing can be further from the truth. And look, the way that I see a contract really is, the contract is really a document that articulates what the parties expect to achieve and what the parties expect of one another. So what contracts do particularly well is they articulate the obligations between the parties. So they say, you know, party A will do something for party B to do something in return. And they also then set out, I guess, the mode of operation, or, you know, lots of different details around what it is that is exactly to be delivered. So, for example, we're having a contract, you know, it might be me delivering a day of training for somebody, or it might be, you know, us having a contract for the purchase of stationery for our office. And what we would do in that contract would be, and then articulate the obligations that we want to get from the other party by having specifications, for example, in the contract. So we say, look, you know, it's all very well to agree to have pens and paper delivered to our office, but if we don't know what that is, we don't articulate it well in the specifications to say, you know, blue pens that actually work and paper that we can actually write on, then you know, then it's all very sort of vague and almost a little bit meaningless. So, you know, I see the contract really, what a contract does is articulate the obligations between the parties, but it also articulates then, or addresses, what happens between the parties if, for example, something went wrong. So if you promised that you would have a project built for me by a certain date, we agree a practical completion date, and it's not done by then, have I built remedies into my contract, say in the form of liquidated damages? So what they are is they're really a template for having clarity, certainty, and understanding between the parties, and there's certainly an attempt at, you know, making sure and that we're good at our language, and that so we'll often have interpretation clauses that might reduce some of the ambiguity. So what we do is we create certainty, we create clarity, we articulate our obligations, but we also address how we operate with one another, and what we actually might do if things go wrong. So they're a baseline, really. Now, one of the things that I do say to parties often is that you've got to not think of a contract as just the baseline and just a document that you pull out when things go wrong. I think that the analogy that I will often use, and maybe it's from my days in building, is that you've got to see the contract as your ally, and your contract is definitely your ally in helping you measure performance, check performance, and understand exactly what's going on with the other parties. And it's a bit like a hammer in a tool belt, so that when you're a carpenter or you know, perhaps an apprentice carpenter, what you learn is that a hammer has, you know, not just one application, which is what you maybe think when you start. Hammer can be used in lots of different ways. It can be used, you know, to really belt something home, or it can be used in, you know, in a subtle way to sort of gently persuade something. And you know, you become a bit of a craftsperson, I guess, in using a tool that's in your tool belt. And so I often like to think that the contract is a bit like, although it would look a bit strange going to site with a contract rolled up in your tool belt, I'll admit, but a contract is actually really one of those tools, and you can choose to use and apply the contract as you see fit for a particular deliverable. And often the contract will build into itself different types of approaches. And so one thing that we'll do in some of the training or courses, or that I teach to my clients, is that you can think about contract management as almost being like a spectrum. And I haven't done a diagram for this webinar, but you could think about there being a you know, I guess a variable sort of or escalation process that a contract helps you achieve. So you can politely, you know, assert your position in a contract, and hopefully that's the way most parties would live under an arrangement when they're in some sort of agreement or an intention to be bound. But equally, if that approach is not working, the contract, through various tools like notice clauses or show cause notice clauses in the instance of construction contracts, allows you to actually turn up your management profile or your management approach from potentially just a polite assertive approach to maybe a more assertive approach, and then ultimately maybe a legally assertive approach if things are really not working. So where you might issue notices about resolution of dispute or potential termination or the application of liquidated damages, for example. So the contract is, this is why I'm really passionate about, the contract is just a guideline, but the guideline is a lovely escalation tool for being able to help people tweak their particular approach according to how that project is running.
Wonderful, Sean. It's really good to know that actually contracts can be used, as your friend, and to make sure that they're continuing clarity and kind of maintaining that relationship, so you don't get to the stage where you're having to use them when things go wrong. So I think it's good to know that if people are properly kind of administrating them, they can avoid all those pitfalls down the line.
Yeah, I just realised that I was a bit remiss and perhaps might just focus on something as well, and I might just draw your attention to one of the slides that I've got in the PowerPoint presentation, if that's okay. And I'll just have to flick through. I'll just there's a slide there about what is a contract, but we can come back to that. But I did actually put a slide in, and I think the source for that was from the Department of Finance. And this is a really interesting slide, and I know it's a little bit hard to understand when you initially look at it. But Holly, if you think about a project, what this particular study or what this particular slide is saying is that we could have a contract, and if we chose a hypothetical delivery time frame of say 24 months, and we can make up whatever we want this contract to be about. It might be our stationery provider. If we have a project that's say 24 months, typically what would happen would be you would go through a contract life cycle, and the contract life cycle would say this: you would have about 1 to 3 months of startup time, and during that startup time you're probably incurring, so that would be when you might be doing your business case, you might be doing a risk analysis, you might be thinking about the form of contract that you're going into, and you're really trying to determine what it is we need delivered out of this particular project. Now, that would account for about 1 to 3 months out of your 24 months time, and interestingly would be associated with about 5% of your spend. We then go into the delivery phase. So delivery phase is that, yes, the stationery company, we tell them to start, they start delivering stationery once a week or once a day or once a month, whatever we need. And the contract is performed. Now, if we think again that this is a hypothetical 24-month project, typically we would say the delivery phase would be about 18 months of that project. But it's interesting because the 18 months of delivery, Holly, is associated with about 85% of our expenditure. We then get to a closeout phase, and the closeout phase might be a natural termination or a natural completion of the deliverables where we're all happy and hopefully, just like the marriage, everyone lives on happily ever after. But it may be then that closeout phase is, another 1 to 3 months, and again would only be about 5 to 10% of your expenditure. What we're really saying is that and typically what people and what lawyers in particular are good at doing is spending a lot of time at the delivery phase drafting, maybe a watertight contract is what they'll say if they're a little bit delusional, but drafting a good contract. And then at the closeout phase, we also make sure all the contract milestones have been met and that we've got warranties, etc. And what we're not very good at as people or organisations is having the contract out, looking at it regularly through the 18 months of the delivery phase, and then you automatically say, well, that's a critical downfall because we're not managing the 85% of our expenditure. So, so it's a really it's why I feel so strongly about this that you can tell I'm already getting worked up about it, but it is the tool. It helps you manage that phase, and without it, you probably do so at your peril.
Yeah, definitely. It's such a strong message, Sean, as I said, that it can be used as a force for good. I guess a query I've got is that, are there ever instances where the terms of a contract aren't clear, or I guess where parties just do things without a contract altogether? And what's the kind of impact of that?
Well, look, you've caught me on a bit of a bad day because just this morning I've been working and advising on a particular matter that is ultimately going into or is already in litigation. And look, you know, I would have to say that this particular matter is a very large litigation matter. And look, just between us, I mean, I can't give you any of the details. I would have to say that really a lot of the fault and a lot of the problem that has come to light as this particular matter proceeds through litigation is that there has been a serious and terrible shortfall by one of the parties to the contract in not carrying out the duties that they had under the particular contract. And so, you know, by not going through and looking at due diligence, for example, things they were meant to do at the beginning of the project and at the commencement of the project in terms of assessment were simply not done. There was nothing that was done in this particular project to identify what they would call latent conditions on this particular affected building. And so what has now happened is that a particular party is being drawn into rectification or remediation works for really work that wasn't under the contract. But had they identified that properly and had they followed proper due process under the contract by identification, report writing, and, you know, really understanding the terms of the contract early on in the piece, then this particular matter, you know, would really be a completely different scenario and a completely different case. So that's a very extreme example of where a contract will not be followed, and it can result in litigation. But, you know, generally, what's it going to do if someone doesn't actually conform to the terms, or if they don't know the terms? Well, look, you know, there may be extreme instances where the parties, you know, potentially haven't executed a contract before they actually start the works, and that happens a lot. I mean, it does actually happen a lot where people say, well, I'm yet to draft the contract, but I need you to, you know, get the works proceeding in order to meet, for example, an opening time. And it's one of the cases that we'll often do in a course as well, as a very famous case called Waltons versus Mayer about a thing called promissory estoppel. And it asks the questions of whether parties can be bound by verbal promises. And really the short answer to it is yes, under certain circumstances. So, you know, often there'll be situations where, you know, parties may not have contract arrangements in place. And that's just horrendously dangerous in the sense that they don't know who's carrying insurance, they don't know about payment terms, they don't know who's responsible for certain elements of work. That's a, you know, that's a pretty terrible situation to get into. And you can have means of getting around it by letters of intent or letters of award. There are sometimes circumstances where the terms are actually unclear in a contract. So again, a very famous case that was from many years ago called Butler Machine Company versus Excello Corp had a bit of an argument around, you know, what happens if I send my terms of contract to you, Holly, and then you come back to me with your terms of contract, and we go through this continual negotiation, but somewhere amongst all that, we just have deliverables under the contract. We just perform the contract. And that case is very clear in saying that, you know, you have to be very careful, because the last party that has the sort of substantive communication, or the judge in that instance used very harsh language to say the party that fired the last shot over the bow actually has the binding terms of agreement before the contract begins. So you have to be very careful about what terms you're negotiating and what terms you're on, and you know, and think about, have I got a clear position at the beginning of the project or before we actually commence the deliverables? Because if you haven't, and I know, you know, I sound like I live in an ideal world, don't I, saying, well, you know, don't do anything without a contract. That's not always the case. You can actually have different arrangements, you know, so correspondence or letters of intent or letters of award that determine or I guess specifically point to terms and conditions that parties agree to is a really good thing. But it's, yeah, it's pretty common that parties don't have, you know, clear terms at the beginning, and yeah, it's just a little bit dangerous. I mean, what we're really doing, I think, is you know, I'm thinking of a sporting game or something, that, you know, what we're really doing is we're just setting up the rules of engagement here. We're setting up how we play, and we say, well, you know, if you don't play fair or you don't play nicely, then we can't red card you, but we can do the equivalent and say we're not playing to the rules, so we've got some sort of resolution. And often what the courts will do, or what the law will often do, will be, they'll say, well, you know, what did the parties agree to? What have the parties signed to in a document? And it's fairly clear that if you agree to it, you have the ability to negotiate it, and you sign into an agreement, then you'll be bound by those terms. That's a rule under the law that's called the Parole evidence rule, or the Four Corners rule. So, you know, if we agree and we write things down, that's the extent of our agreement, really.
Yeah, definitely. I love the phrase, the kind of rules of engagement there. I think it nicely sets up, you know, what can happen if you don't manage these things properly. There's obviously some severe consequences, but obviously using a contract, referring back to it, and making sure you're following your own rules that you set up. So I think that's a really nice analogy there you've used. I guess,
that's
Sean,
right.
you've
There's
quite a lot.
Sorry.
No, go on.
I was just thinking occasionally there are, you know, thinking of matters that I've worked on over the last couple of months, and, you know, one of them, again, a very simple sort of contractual dispute where one particular party had some agreed methodologies of how they'd go about doing the work under their contract. They decided for their own convenience and really for their own benefit that the method that was outlined in the contract was, they thought they had a better way and a more efficient way, and perhaps even a more profitable way of doing the work as well. And they did that work, but they did that work without advising the other side or even seeking a variation or agreement. And now, of course, what's happened, they're in dispute because the party that is affected by that work has said, well, it's not in accordance with the agreed specifications at the beginning. You could have asked us about it. You didn't ask us about it, and we now believe that you're in breach of contract. And that's a pretty sound argument to say they're in breach if they haven't altered the terms.
Yeah, never going to end well, huh?
Never going to end well. That's right.
So, Sean, you're obviously very passionate, and you've got a huge depth of experience from both your time in industry and law, as we've mentioned. But how do you actually teach this stuff? Because it can be obviously quite a daunting topic when you're looking at contracts. So how do you impart that knowledge?
Yeah, look, there's a few different ways and a few different methods, and I think that I mean, what you've asked is a great question, because there has to be a method, or there has to be a different way, because, you know, often organisations are, you know, not particularly good at training their people. So we might say, look, jump in, you know, manage a project. We know you've never done a $5 million project before, but, you know, good luck and see how you go. And we sort of throw people in and think that experience is a good teacher. But I don't believe that that is the case. I think that you have to build people's confidence. And so what I would do in terms of teaching people, and, you know, it's through courses and through working with clients as well, is that you gently expose people to, you know, the terms of contract, and you gently expose people to, you know, the basics about law and what does it mean to be actually, you know, in a contract, and when are we bound, and, you know, what are implied terms and what are express terms. So we'd normally start, for example, in a course with, you know, running through the basics of law, running through the basics of a contractual relationship, thinking about what it is we're trying to achieve by being in contract. But then we we just practice the skills, really. So any course, if you think of you know, or any advice that you would give to a client, you might actually take them through and say, well, you know, what is the particular issue here that we're facing, or let's practice some interpretation skills on a contract. So we might look at some clauses and say, you know, what's that clause really saying just strictly in the black letter law, and what's it really intending to say? And so we practice a bit of interpretation, and then you teach people some theory. So you teach people theory about contract law, about you know, when are the parties bound, what is an offer, what is acceptance about. People need to know the rules, because there are rules around contracting, for example, that you're not bound unless you've really got 5 to 7 elements that have transpired for you to get into a binding agreement. So you need to teach some theory without question, but you then need to be able to get people to sort of I guess get amongst it and engage by looking at case studies or doing some activities or practicing. And so often, you know, I think the best way to learn is by doing, and we all know that adults, for example, learn in various ways, and some of us are good at reading, and some of us are good at listening, and some of us are good at, you know, engaging with people, and some of us like to do online learning. So you need to just get people, you know, I suppose find where people are happiest with their learning, use a combination of them, which is normally best for most people, and then practice the skills. And what I mean by practicing the skills is looking at a clause, thinking about some exercises, doing a claim, for example, and doing a mock claim, and then applying it against the contractual clauses or clause that it might be relevant to. And you know, it's simply like I think I used the analogy before, the sporting analogy, to say, you know, it's miles in the legs. If you do it once or twice, you don't have to go through and read the whole contract from, you know, page 1 to page 197. You just need to look at isolated clauses, think about what are they trying to say, think about what the intent is, apply it to a scenario, think about the cases that we've learned about and some of the theory, and then just have a go at it. And you know, sometimes we do it really well the first time, sometimes we do it terribly, and we just practice it over and over again. But you learn by yeah, just getting amongst it and trying, really. So yeah. Often what we do is, you know, we break a contract down into its simplest terms, and we say, you know, think of a contract being who does what when, which is mostly what contracts are about. And we say, all right, if I was to draft a clause or draft a deliverable in a contract, for example, or think about what a contract actually or clause actually means, sometimes just applying and learning the who does what when approach to drafting is very, very helpful, because you say, well, all right, first thing I'll do when I draft a new clause is I'll think who's going to do what, and then I put that in one sentence, and then I move on. And it's very, very helpful. So there's, you know, there are efficient tips that you can actually pass on to people. Similarly, you know, often people get caught in contracts managing claims. So when I say a claim, I might mean a claim for payment, claim for an extension of time, or a claim for a variation, or claim for damages. There is a prescriptive approach you can take to most claims, and you know, it is a prescriptive approach that can be taught to people. 5 steps that you take away and you remember. I won't reveal all my secrets here today, except that there are 5 steps that if people remember that, you know, look, I get feedback all the time from project managers and engineers and contract professionals that having learned some of those simple tips has really helped them become much more efficient and a little bit more confident. The other thing is that, you know, dispute resolution. We talk about dispute resolution in some courses, and let's face it, we should all learn how to negotiate, because we negotiate at home as well as negotiating in contracts. There are a few tips and a few simple rules to good and principle-based negotiation that you can really only learn by, you know, learning them off by heart to start with, and then practicing them, yeah, and applying them. So yeah, I mean, teaching people about good contract management is about giving them the tips for efficiency, really.
Yeah, I think you've hit the nail on the head there, Sean, with tips and tricks, confidence, and obviously having that chance to practice. We all know when we're actually transferring those skills and practicing them, we can then think about how we can apply them back into our working environments as well. So I think that's a good mix there of making sure people have the confidence and the chance to practice. So that's definitely top in themselves.
That's right. Yeah.
And I don't want to sound too negative, I guess, moving forward, but what are some of the, I guess, negative consequences or difficult things that come out if people don't know how to effectively administer and manage these contracts?
Yeah, well, look, I mean, it's almost no question that, you know, if we don't know how to manage or how to administer a contract, I guess, you know, there's a few things that I can think of. You know, one that you could potentially be, I don't want to sound adversarial or nasty, one that you could be, you know, walked over by another party, for example, and they say, well, you know, this is what it is, this is the way it's always been delivered, and this is what we're expecting. So, you know, knowing your contract helps you to be able to firmly or politely assert your position and hold your ground. Certainly, if you don't know how to administer a contract, I absolutely believe that there are certain situations where you could hold your ground. So, you know, if a contractor makes a claim from you for payment and they are late on their payment claim, and the agreed terms are that, you know, the payment claim has to be in by the 25th of every month, you know, by learning a few contract skills, you can be confident that you can apply a black and white sort of interpretation to that and say, well, if he's late and he's out on his payment claim. So again, it helps you assert your position. I will also go back and reiterate what I said earlier, that you know, if you simply learn to manage a claim in a timely manner, or you know how to more confidently handle an extension of time, or you're good at a variation because you're feeling comfortable and confident in reading the clause and knowing what the actual formal process is, or indeed you're confident at dealing with and you know how to follow a dispute resolution process because the clause articulates well what the dispute resolution process is, you are really, again, saving time, saving money, saving grief and saving stress. So there are lots of benefits there. And I guess the third part of that answer would be that ultimately, by managing a contract and being able to effectively administer it, I hope that you stay away from my litigation example that I provided earlier in the day to say you can potentially avoid those situations, because my view on that particular matter is that, you know, had those people been properly advised about what they should have done at the beginning of the contract and followed that contractual process, then they would not now be facing, you know, a significant escalation in legal costs and a fairly significant sort of legal matter. So good contract management and administration, look, it makes life easy, it makes things efficient, it makes life a little bit more pleasant. You know, when I remember years ago as a contract administrator, I enjoyed my time as a contract administrator, and sure, there are arguments and barneys over subjectivity and who you know, what was in the scope and what wasn't in the scope. But, you know, once you're practiced and confident at it, you know, life just becomes a whole lot better, I think.
Yeah, definitely. It's good to know that those pitfalls can be avoided and that people can obviously avoid the costly litigations and things just by making sure they have that confidence and insight into managing them. So, Sean, thank you so much for your time today. It's been wonderful to chat with you around how people can kind of be more confident and skillful with managing contracts. Please do stay on the line, everyone, and keep answering and asking any questions you have. We'll get to questions in a few minutes, but hopefully Sean has given you all a bit more kind of confidence that you're not alone in these kind of difficulties of looking at contracts and how you can make sure you're protecting yourself and your organisation. So we're just going to go through now. I think, as Sean mentioned, we do obviously run a number of courses which we're honoured that Sean runs for us. Some of the ones that he runs for us are contract management and administration fundamentals, contract negotiation. We also run training on contract law at a variety of different levels. We're also honoured to be learning partners of the IACCM, and they actually allow us to offer attendees to our courses continuous professional development points. So not only are you kind of upskilling yourself, building confidence, it's also part of that professional development. We will be sending out a follow-up email from this webinar, so you have all the information on the courses that we offer, all the kind of contact details to get in touch with us. We're also delighted as well to offer anyone on the webinar today a discount on our training courses. So please do look out for that. We'd love to welcome you to some of the courses that we run in the future. Sean and I as well personally do work together a lot for very customised in-house clients. And we love working with clients to understand their exact needs. We customise the course and use their specific contracts. So if you have a team as well who you think would benefit from some expertise, Sean and I would love to hear from you. So please do get in touch with us in due course. So we're actually going to move on now to some questions. So you can keep them coming, because as we go for the questions, we can still keep answering any of the questions. So the first one I've got here, Sean, is from someone that says, I work in the water industry. Just for a bit of background, actually, Sean's got a strong background in the water industry, so that's interesting. I work in the water industry.
Holly, we had the joke the other day that someone had referred to me as the water lawyer, because I've now got, I think, 6 or 7, and between you and I, we've had a couple as well.
Yeah, we have, definitely. So yeah, I work in the water industry. I'm just wondering, what are the terms of a particular contract that I should be focusing on the most?
That's a very good question and almost a hard one to answer without having a little bit more context. Maybe I need to make an assumption to answer. That's a typical legal answer, isn't it? To say I need more information. I can't give you a straight answer. Maybe I can make an assumption, and perhaps the assumption might be that the person who's asking the question from a risk view or even from a negotiation point of view. I feel as though it's a difficult question to answer, but perhaps I could simplify and say, if you're looking at negotiable terms or looking at sort of key risk clauses in a contract, there's probably about sort of 6 or 7 that, would be the ones that you'd really be focusing on. And they would be perhaps your insurance clause, definitely your indemnity clause, your defects and warranty clause, latent conditions, extensions of time, variation clause. So, is there a good and easy process for being able to get variations, for example? Although if you're a water client, you may only want to have variations that you tell a contractor about. But look, latent conditions definitely for water contracts. Extensions of time is very, very important. Practical completion, even separable portions as well. So sorry, that sounds enormously technical, doesn't it? I hope that answers that question.
No, it's good. I think obviously you want to make sure you're focusing on all of them, but that's definitely a good one. Another one here that I like that says, is articulating your requirements too clearly sometimes a bad thing that hinders the flexibility of projects? For example, changes to quantities where the dollar is the same?
Yeah, that's an exceptionally good question. I have to say that there's articulation and there's articulation. So articulation, as it relates to that particular question, is quite specific around the quantities and the scope and technical specifications. And I have to say, the better, clearer and more concise you can be in your specifications, then the safer you are, particularly in terms of schedule of rates and how you agreed prices might vary. The contrary is true sometimes for clauses in a contract, though, that are not specifically about quantities or methods or work levels. Sometimes ambiguity is actually a good thing, so that if Holly, you were coming to my organisation and you were doing training, I might say I want you to to use your best endeavours or to make the training fit for purpose. Now that blanket sort of broad and ambiguous statement is probably quite good for me, because I can use that, and we can probably both use that to say there's kind of an agreement about what the standard is. And if we wanted to draft a more specific standard in a clause, we could be drafting from here until Christmas 2020, and it just wouldn't be practical. Good question.
Yeah, that's a good one, that one. They've got some, they're testing you today, Sean.
Texting, oh yeah, testing, that's right, exactly. I feel like I'm earning my lunch today.
Yeah. There's one here that we potentially might need to get back to and follow up on, but I'll ask you it anyway. It comes from a gentleman who's recently moved here from Dubai. I'm just wondering if there's any recommended articles on comparing the use of FIDIC versus contracts used in Australia.
So I can't specifically address you to an article, except that I could happily and confidently say there are a good number of articles that address this on many occasions. So I think if the gentleman does a Google search to say, how does FIDIC compare, they're called FIDIC contract, how do FIDIC contracts compare to Australian standards, he will find some good information. There is information, the contracts from, those FIDIC contracts are not as widely or well known in this jurisdiction, but certainly a Google search would reveal there would have to be something. I feel quite confident there'd be something that would make a comparison. In my own view and my own experience, I think that, we deal a lot with, there might be sort of more cooperative and collaborative kind of clauses in perhaps in the FIDIC contracts than the Australian standards, but I just don't have enough experience to really specifically answer it. But a Google search should reveal quite a lot of information on that. Okay, and there are books as well about different forms of contracts within Australia, so we could provide those separately.
Okay, wonderful. I hope that helps on the line with that one, some of the Google searches you can do. There's one here, Sean, that I think I know what you're going to say to this one, and it says, can you ever do more harm than good if you're administering and using the contract, or is it better left sometimes in the drawer?
Yes, that's also a very good question. Is it better left sometimes in the drawer? I would say, you know, one of the things we do is we do a bit of, I mean, I've done a lot of negotiation training, and I will take people through negotiation in any of our courses, Holly, as well. Sometimes I say, what's the answer? What would most people do in the early stages of a dispute? Now, from my practical experience, I would say what I would do would be probably I would want to know that I'd looked at the contract and that I'd read it and that I was absolutely au fait with what the terms are. You can't hope to have a good resolution or a good dispute negotiation unless you know what you were up against, or what your baseline is, or what the dispute is about. So you have to read the contract. However, sometimes, look, it's actually really helpful to pick up the phone and say, what's going on, Holly? Can we just have a chat? And maybe we don't need the contract in that discussion. So I would say yes in many instances, but you need to have done the work before you actually. So maybe I'm saying that you appear to have a non-contractual negotiation, but you still know the.
Yeah, you've got to know that inside out before that can be applied.
You absolutely do. But there's absolutely no harm in going outside what the terms of the contract are and saying, let's just meet, let's have a coffee, and let's see if we can resolve it. That is the best and most effective method of dispute resolution that you can engage in.
Yeah, definitely. Good advice there. So we've got another one here that says, what tools within a contract can be used to safeguard Australian customers engaging with US suppliers who are not registered in Australia to ensure that deliverables are met and remedies can be enforced?
Okay, I probably need to hear the question again. But there's a couple of things that I can think of. So one, you might think about the jurisdiction clause that's in the contract. So you might say the laws of Australia will apply, for example, and that'd be great because then you know you're protected by the Competition and Consumer Act. So enforceability may be a little bit of an issue against the US supplier. The other thing is that in your specifications or your warranty clause or even your defect, probably not your defects clause, but your deliverables clause of some sort, would be that you might have a third-party reference to say goods or windows will, for example, meet Australian standard number XXX. That is a very, very, very good way to be able to ensure that you've got some sort of compliance. You can have a blanket statement, maybe under the jurisdiction clause as well, but probably under the specifications clause that says, you know, they'll comply with all relevant standards or all relevant requirements within Australia. That would be very, very helpful, but you need to then think about enforceability as well, which could be a little bit tricky.
Definitely. A few things to think about there.
Yeah.
So another one we have is there a limit to the amount of variations to an existing contract?
Again, that's a very good question because usually no. So a variation clause, I've never seen a variation clause that says, you know, variations will be capped at, you know, 30 or capped at, you know, X percentage of the contract. You do have to be a little bit mindful, though, particularly in government context, that, you know, substantive variations that vary, that make the contract so removed from its original scope or so unlike its original project that a government context might sometimes say, I have seen clauses that say variation must contemplate that the project remains sort of true to its original form or something like that. So that if I say, well, yes, build me a cubby house, and then I go into a contract with someone, and then I say, oh, and by the way, please build me a bridge. You know, they're just, and I do it as a variation. I think that would be contemplated as being outside the scope. But look, domestic building contracts, I see examples often where builders have had a year-long build, or, you know, a 2-year-long build, and they've got 140 variations. So there's strictly no limit to them. The limitation that you have to be really careful of with variation clauses, Holly, is often a thing called a time bar or its prescribed form. So domestic builders, I've had many difficult and hard conversations with domestic builders that have got to the end of a project, and they might have 140 variations, but if they've not met the time frame for submission, which might be within 14 days of the variation occurring, then they're eliminated. You know, it's a horrible conversation to tell them that they've lost 10% of their profit because they can't get all the variations. So you have to be careful of time bars, really.
Yeah, I think that focus on time bar is a really good one. I think a lot of people know about it, but it's about making sure that it's always front of mind. It can be so costly.
Yeah, that's right.
We'll go through one more here. It says, can you recommend a useful contract management or contract law for contract managers text?
Oh boy, that's a good question. That really gets the cogs turning. In terms of contract management, no, because this is one of the reasons I'm really passionate about it is because I think it's still a bit of an under-resourced area. But I mean, that's why it's great that you guys have the stream of subjects that people can do to actually qualify. Look, in terms of books on contract management, there's not a lot. There's one that's done by the International Association of Contract Management. It's called the IACCM. I've just lost the full name. International Association of Commercial and Contract Managers, I think. Now, they have a good book that is about contract management, and it's a very dry read because there are no real life examples. It's all theory, but it is quite a good book that you can pick up. There's lots of online resourcing. So Partnerships Victoria, for example, is a government arm down here that produces some lovely little contract management manuals. ANAO, the Australian National Audit Office, Department of Finance, they all have nice contract management books or manuals. I hope to write one day when I get some more time and Informa doesn't keep me so busy. Maybe that'll be a retirement plan or something. In terms of contract law, look, there's a few good ones, but the only ones I can think of are sort of the fully legal texts, and they might be a bit too full of legal. So if you do a Law Institute search and look at LexisNexis, they publish lots of books on contract law, but they would be very theoretical and very sort of legal, actually. So I'm not sure whether there's contract law for dummies. I've never looked for that.
Awesome. Well, yeah, some good insights there. I think that brings up quite nicely as well, Sean, of if you can bring up the slide where it's got a bit more information on the courses and our contact details. If anybody does have any other queries or questions, they can contact us. But as we say, we will be sending out a follow-up email. But you can either phone us on the phone number that's now on the screen, or you can email us at training@informa.com.au. And as you mentioned, if you do want any further information about the courses, the training that we run, here's just a snapshot of some of the training courses we do run. We also do a wider suite with courses that are related specifically to contracts in oil and gas, for example, or specific industry-related contract courses. And also, as you said, we'd love to offer people a discount on some of our upcoming courses, so get in touch for our schedule. Sean, as I said, thank you so much for your time today.
Yeah,
it's been wonderful talking through this. And yeah, please do get in touch if we can help, and we hope to see some of you at our training courses in the near future.
Thanks, Holly.
Thanks, everyone. Have a good day.